how bad is what SBF did really? Wait, stay with me. The collapse of FTX, the billions of dollars wiped out, the companies that were caught up in the contagion, that was all really bad. But SBF doesn't need to prove someone else caused the crash in order to win an acquittal. He just has to get one juror to believe the story he's already told the rest of the world. He may have messed up, but at the end of the day, he was trying to do the right thing. So in the fourth part of our series, we take another look at the charges against SBF in the context of everything we've learned, and ask, even if it seems infinitesimally unlikely, could SBF walk? At his trial, SBF will have to defend against 7 counts. The first, wire fraud on the customers of FTX, and 2, conspiracy to commit wire fraud on the customers of FTX. 3, wire fraud on lenders to Alameda Research, and 4, conspiracy to commit wire fraud on those lenders. 5, conspiracy to commit securities fraud on investors in FTX. 6, conspiracy to commit commodities fraud on customers of FTX in connection with purchases and sales of cryptocurrency and swaps. And 7, conspiracy to commit money laundering. And that's just for the October trial. A second trial in March will litigate 5 more counts, like his crimes against fashion, taste, and the reputation of Larry David.
I don't think so.
All right, nah, I'm kidding. It's actually just more fraud stuff. But as for these 7 counts, the government has one job: create a simple narrative. SBF represented himself as a trustworthy and law-abiding crypto businessman, yet the whole time he was misappropriating customer funds with abandon for lavish spending on real estate, political donations, business investments, and anything else that he felt like spending his money on. All the while, he was lying to FTX customers and Alameda's lenders about the actual workings of the company. SBF's intent, according to the government, was always fraud. On the other side, SBF's defense is also pretty simple. He isn't guilty of fraud because he wasn't acting with an intent to defraud anyone. He may have given Caroline Ellison too much power, as we covered in Part 1, and trusted his lawyers too much, as we covered in Part 2. But at the end of the day, SBF claims he just wanted to do the most good for the world he could. Remember the fawning profiles about how SBF was going to save the world?
The guy you see next to me is the most generous billionaire in the world, and I found him.
Look, SBF isn't Bernie Madoff. And that's not even me saying that. It's literally the first thing Mark Litt, Bernie Madoff's former prosecutor, told us.
It's not clear to me that this is exactly a Ponzi scheme, but securities fraud is securities fraud.
Madoff's decades-long Ponzi scheme was never a legitimate business. Even the prosecution agrees that FTX, as a business, made hundreds of millions of dollars a year, and that's despite the legal and technical complexities of running a crypto exchange. And all SBF needs to do in order to avoid jail time is convince one juror out of 12 that some reasonable doubt exists around whether it was SBF's intention to commit fraud, though he will have to do that for each of the 7 counts. He'll also have to overcome the testimony of his 3 top deputies, Caroline Ellison, Nishad Singh, and Gary Wang, who have all flipped and are testifying against him. If only his staff were ride or die like a certain strawberry blonde someone. But that's where we move from the facts of the case into the politics of the courtroom. And for that, we turn back to Mark Litt. When you look at, I guess, kind of what's happening here, and I guess the fact as this goes to trial that you're going to need to convince 12 jurors that a crime was carried out. I mean, how does that element of cryptocurrency, or the fact that maybe it's not as simple as an outright Ponzi scheme, what does that do to the prosecution side, the defense side, when you think about what's going to happen in this case?
I don't think it changes it all that much. In a trial involving an equity stock or a bond, you may have to do some explanation to the jury about some of the terminology they're going to hear about. Cryptocurrency is newer. You might have to do a little bit more of that to provide context. But the case isn't about cryptocurrency. It's about, again, representations made and not kept. It's about taking money from one pocket and using it for purposes of another company in another pocket, without the investor knowing that, and with taking efforts to conceal that. That's not hard for a jury to understand. I mean, the defense may want to make it about cryptocurrency, but it's not really relevant to the charges. And even in those category of cases, well, look, the cases that are triable cases, what I would call a triable case, where the questions are close, there's generally a much better chance for a defendant to get a hung jury or an acquittal than in the category 2, where it's kind of the Hail Mary situation where you have nothing to lose and you might as well, but the facts may be overwhelmingly against you.
So that seems to be the chance is slim, is what I'm hearing. It's slim, and you're looking at a 12-person jury. You're going for one of those people to say something.
Yeah, and you got to get one person on each of 7 or 8 counts that are being tried in this first trial.
Okay, so not likely is what I'm hearing.
Yeah, but I would say that with respect to almost any criminal case in federal court, it's not so much special, you know, that assessment is not so specifically directed at this one.
Yes.
But there's nothing about what I've seen in this case that makes me question that assessment.
Connecting the dots back to your days prosecuting Bernie Madoff in high-profile cases like these, obviously, I think any sort of news coverage out there might impact a potential juror, and you have the prosecution making that point ahead of the trial. So on that point, when it comes to what a potential jury may not see, but hear, how big of a factor is that in trying a case like this, both for the government and the defense?
Well, the two sides have different incentives and goals. I mean, the government would like to have a hermetically sealed trial record that's within their control, and that they know what the jury is going to see and hear, and not have any outside prior influence. And, you know, on the other hand, a defense that may be constrained as to what they're going to be able to bring out in evidence is going to want to try to do what they can to prepare the battlefield and prepare the potential jurors for what they're going to hear. But, you know, the Southern District probably has 1.5 million people. I don't know how many potential jurors. I mean, the odds of succeeding at that in some significant way are low.
Yeah. You've seen, I guess, you know, again, a lot of these cases before. Prosecuting Bernie Madoff, I mean, when you look at maybe potential mistakes that can be made in a case like this, from a prosecutor's perspective, what are you maybe thinking of?
I mean, in general, the biggest mistake I think prosecutors can make, and I don't think these prosecutors will, is to make the case more complicated than it is. Prosecutor's job is to simplify it, and to make this a 2 to 3 week case, not a 3 to 5 month case. And Judge Kaplan won't allow it to become that. But a prosecutor has to keep it short, compact, direct, clear, linear, and comprehensible to a jury, and take all of the jargon and crypto specialization out of it and make it about fraud, pure and simple. It's as simple
Sounds simple.
It's as simple as he said he was going to do this with the money, but he did that. That's fraud. That will be, in a more flowery way, in the opening and the closing and the rebuttal. I can guarantee it. And the defense will take the opposite approach and try to confuse the issues, draw all the complexity they can out of it, and try to persuade at least one juror that that complexity casts doubt on his intent and his lack of criminal mindset.
You keep saying
So
at
it's
least
the
one
opposite.
juror. Is it because that they would be the one in the room saying, look, no, we gotta...
It's one juror to hang. Your goal as a defense attorney, sure, you'd love to get an acquittal, But to get an acquittal, you've got to persuade 12 jurors that the government got it all wrong, and all 3 of these witnesses lied. And the documents don't say what these, nice young lawyers wearing the blue suits from Team USA have got it all wrong. It's a high hurdle to overcome. An easier hurdle to overcome is to persuade 1 to hang, and then you make the government try the case all over again.
In terms of, you mentioned kind of having 3 co-conspirators that the government's now working with, right? You could look at that as a 3-on-1. You could look at it as not necessarily great odds that you're going up against in terms of already having those witnesses playing on the side of the prosecution. I mean, when you put all the facts together, what are the odds of a conviction?
Well, first of all, I can't put all the facts together because I'm on the outside looking in.
Yeah.
I see the indictment, and I can read press reports, and I can use my imagination to fill in the gaps based on my experience. But you can't assess that kind of thing without actually meeting the witnesses, having an idea of how they would stand up, how they would present to juries, how they would present as witnesses on direct.
Yep.
What is the grist for cross-examination? But look, based on the odds, I don't know what 95% plus of all federal cases wind up in a plea or a conviction. There are triable cases, meaning cases where it's close, and then there are cases that go to trial just because it's just too big. There is no deal to be had. There's no cooperation to be given, and the reputational damage is done. The business damage is done. And any way one turns, one is looking at really bad options. And those cases can go to trial too if the defendant has the resources to fund that kind of operation.
So how bad was what SBF did? There's no real objective way to measure it. Bernie Madoff's Ponzi scheme was a multi-billion-dollar ruse that ended in a sentence of 150 years in prison. And he also pleaded guilty, and there was no underlying business. Given that even Bernie Madoff's own prosecutor also admits that this wasn't a Ponzi scheme, it's hard to compare the two. And by heading to trial, Sam might be affording himself an opportunity to make that point even clearer, and maybe even clear his name in the process. As we have been since even before FTX collapse, we'll continue to track SBF's defense at Coinage.media. I'm Zach Guzman, and as always, stay safe out there.